liability the district might be in is the context of the questions and the discussion is likely to change with each and every board member who's having that conversation. Therefore, you're going to come back likely that should happen. It's also very difficult because what I found in going through this is the attorneys are not, they're not working with us in the sense of, here's likely what is going to happen. You're going to see 3 different options, and these are the different directions we'll take based on what option comes out, whether somebody turns left or turns right. They will give you a proposed solution for the situation that is directly in front of you at that point in time, and won't go on beyond that until they get the next set of definitive information to deal with.
Do you have in mind, or does the policy have in mind, if board members, the board member wanting legal perspective on the decision that's being made about the district? Or is it a board member looking for legal advice on their own liability, probably, and indemnity or not? Is it the latter?
Yes, I don't think that there's anything that would preclude any one of you to go out and seek your own advice as it pertains to you as an individual. And it would be your expense at being able to do that. Versus, I think what we're talking about here is representing the district, seeking advice for the district. That answer.
Right. I'm trying to think of an example when this would come up.
I think the last one was an example to where individual concerns probably were and should have been, because they were from me as an individual. Because what I kept hearing was there is no recourse because it's a constitutionally protected activity. However, when the entire picture was given as far as what was taking place, then it became, oh no, there is actually a path forward in doing this. However, you are likely on appeal going to lose because of not being a liberal or conservative group, and you're likely to be sued at the federal level as well. In which case, that's where it's going to cost you hundreds of thousands of dollars, regardless of the outcome, just in having somebody create documents and motions and.
So the individual name, right?
Yes, and the question then becomes, are you indemnified from any sort of legal recourse in that? And I think we all have to understand that it doesn't necessarily keep us from being sued. It's whether or not when the judge sees it, and we've got OSBA or PACE in everybody else's term, a lawyer going and saying, this is the law, this is why they can't be sued over this. They did what everything they did, they followed in good faith, and they were doing their jobs. Having the judge say you're right, they throw it out. I think we've seen all of now, there's cases in which we may run into a judge that says, disagree. In which case you can have appeal. Dealings with the BPAA and the recommendation.
Let me, for option A, OSBA Norm Pacey will interact, will engage with any one individual board member. Will they? They'll just say, you need to, we can only engage with you if you need to talk to your board chairs, specifically, they're gonna tell you, well, you know, you gotta go into board session and decide as a board whether or not you're seeking this information and exactly what you're seeking, kind of like what B says.
Yeah,
So I mean, I don't even see that, unless something's changed recently, I don't see that today's even an option based on how SBA and PACE operate.
but I think you're referencing on it based on how we currently conduct business, which is more like option B, with regard to the change. My take is that if the board wanted to adopt a policy and have language similar to option A, and that was our policy, then yes, they would work with us on providing each individual board member a conversation. Now, they may be right, come back and say, this is not a good use of our time. Can you guys have a conversation, direct it back towards an individual and bring it back to us?
A sounds like a terrible idea.
I think so, and this is what you're following, if you follow across to what's happening across the river, this is exactly what's going on.
Well, my only hesitation is what you guys were just discussing is personal liability of like getting to a point, and I understand that that's not a very likely scenario. However, I feel compelled to bring it up simply because of my day job, where they do make attempts on a regular basis when there's lawsuits to name caseworkers like individually and try to portray that you have worked in some fashion or other outside the bounds, the scope of your job. And if they're successful in doing that, then you're no longer covered as an employee acting, as a representative of the state, that you essentially acting as an individual and that your own personal assets are exposed at that point. And so, I wonder what options there are. To getting, like, given, depending on what the situation is, if we ever come into another situation where that may even be worth considering, because at that point, if we're going to be, we're going to go and have to talk to our own attorney anyway. And then at that point, we're already starting to spend our own money.
Well, I think we just have to, as a group, decide, oh, we have these concerns, and then have the chair bring two days for SBA, you know? It's just, we can't have one individual person go to base, you just have to, as a group, you can ask all the same questions, just has to be answered.
Well, that's what I'm trying to clarify, if
We have trust amongst each other that if somebody needs it,
Right.
well, I would like to think that if one of us is concerned that we're exposing ourselves to personal liability, that would
To be all of us.
Yeah. we'd be all in the same boat.
Yeah.
And I'm just making sure that those are questions that still gonna be asked and answered if we're going with B.
Yeah, and I think where they the experience I had this last year is the understanding that in terms of our attorneys, whether it's Hungerford's or it's PACE, they are answering questions. Hungerford support the district. PACE, I think we can get into more detailed conversations as a board.
And remind me, who do we have? I don't know if we can discuss this, sorry. Discuss.
Bases are insurance carriers, they are going to work with us on cases of liability. There's a point in time where that changes, so Brian would go with this clear through and appeals to the various dismissals appeals board. And then that decision would be final and Brian would be done. If we were then to be sued, then PACE would start to take over that.
We would want some direction well before we got to that point.
Yes, and that's why we work with them all along that point. PACE generally wants to know what is happening. They will then tell you, yes, we will support you in this, meaning yes, we will Waive your $25,000 deductible because you let us know this is happening, we're able to provide some guidance, but there's really nothing for us to provide till it gets to that level. And it keeps informed by what is happening, which is what, what I would do. Brian leads us all the way up to the employment side of it. To the fair dismissal board. Neither one of them, I don't believe, I'm trying to think it's an attorney right now, would provide information or support for an individual. They would do it as the, that makes sense.
Yeah,
Or
that makes sense, but,
It doesn't.
yeah.
And I think that's some of it's that's a lot of, again, what is going on across the river in terms of individual board members seeking information. When they have policies that and practices that say that is the role of the superintendent outside of the board directing an individual board member to go seek that information out. So for instance, contacting the Department of Ed and saying, where are we at with this in regard to a complaint regarding the district. And that's not a case we usually generally have to be worried about being sued about. Yeah,
but the one that you're talking about the same thing. One board member is suing the district for policy violation, serial, what do you call it?
communication.
Communication, right?
There's, government ethics complaint.
So if that were in this scenario, what we'd be asking the question is not the lady who sued, but the people who was suing, but the suees, the defendants. Can they each go and get recommendations, or do they have to go as a group and get a recommendation?
Yeah, I think a better example is the COO and the Human Resources Director have tort claims filed against now 3 board members. Part of that is saying that they retaliated against them for violating their own board policies. Out of that, they've essentially let them know in the complaint. I would imagine the complaint is, or the body of the complaint, the tort right now. So once they go to the actual lawsuit, the claim that they are going to make is that the board members were operating outside of their authority that's presented to them. The board members, individually or as a group, if they came together as a group, would have to say, no, we actually operated within our authority, here's our policies, and it's where the evidence comes out. So that is actually probably a really good example of the difference between operating within your authority and operating within the authority and the information that you have, or doing things outside of the authority that you've given based on your policies.
And I know that makes sense, but in terms of this policy, if it was the 3 of us that were named in that board, this is addressing whether Drew should go get his own representation, and Jen should get hers, and I should get mine, inside of the district's legal representation.
This is only saying whether we can individually contact.
Yeah.
That's what I'm saying.
Right.
This is saying that you can, or shouldn't.
And what I believe would need to take place is that if 3 of you had a tort claim against you, would you be able to reach out to PACE to see whether or not you recover, or would you have to go to an individual to do that as far as recovery in the district? I think that is the question. Yes.
But Again, it just seems to me like the differentiation here is clearly the three of us can do that. But can one of us go to one, I don't even know why you do that.
So,
I could see if I said something egregious personally, and I'm worried about what I said or something along those lines, but I'm going to my own attorney at that point.
right,
So
so the question becomes, like, from a government standpoint, once you have a tort claim filed against you, is your response, I'm acting as a board member, therefore I'm protected under the policies and I'm supported by the district. Pace at that point, and so this is I think how it would go, so. If the superintendent is available to ask those questions or bring Pace in, then you could do that under option B. If the superintendent was the one that was filing the tort claim, the superintendent would be out of it and you're left with your chair, right? Or your vice chair, or you would make if the vice chair and the chair were the two being named, you might, decide, hey, we're gonna make a motion or resolution that we elect such and such to do this on our behalf. They then can provide that information. My guess is gonna be based off of, the information and what may come out of it. ACE has got to make a decision of, yes, we will support you because we feel like you did everything you're supposed to, or no, we're not going to support you because you never even reached out to ask us, or you did and we told you and you went against our.
But again, you're talking about three of us,
Yeah.
not one of us versus a different one.
This is what I would say, that's a great point. What I would suggest, let me do some research. This may actually, and if you guys are okay with that, bring this back as another review.
That's fine. The only thing I would do is change what B's first line is to say, all legal requests and advice coordinated through the board chair, superintendent, or board designee. Because it was, the wording here, it has to be superintendent or board chair. And if they're both unwilling, but somebody really wants, you know what I mean? Like, if the rest of the board voted for somebody else to go seek advice, then they still have that ability.
Are you looking at the option?
What should be the first line?
Yeah, the actual proposed.
I would propose that it change it, if this is the one that we end up going with, say, requiring requests for legal advice to be coordinated through the board chair, superintendent, or designee, or something along those lines. Like if we all designated Rusty to go do it, he could go find people work for Pace or whatever.
If you work around based on the law.
Right. Or what the situation is.
I do pretend I'm an attorney at work.
There you go, you're good to go.
Clearly, this is a policy for what's in that address.
Yeah, it's interesting, we have a live world example here. Yes.
All right, so the actual, if you go to page 6 of the model sample, it's under number 2, requests for legal opinions. So this considers how board members obtain legal advice and whether costs is associated with that. Does the board want individual board members to be able to contact attorneys at PACE or OSBA, no bill accrued on their own, or does the board want them to be board approved first? Do you want individual board members to be able to contact attorneys that will be bill the district on their own, or do you want them to get board approval first? So it's really centered around whether or not it's going to cost the district money or not. So number 2, requests for legal opinions. Requests for legal advice or opinions by board members that will incur a cost for the district must be approved by a majority vote of the school board. The request is made to legal counsel. The board chair is authorized to obtain legal advice or opinions if advantageous to do so prior to the next board meeting.
Sure,
Well, I think that still would be,
right, you still want that in there.
well, you'd want that in there, but is this where we would want board chair or board designee? Because this says the board chairs, the only authorized to obtain legal advice or opinions.
Before the next board meeting, like if it's advantageous, that last line is just like, if something immediately happens,
It doesn't designate to
Right.
superintendent or chair,
right, for the current.
the proposed.
I mean,
So language
it
was,
says, approved by a majority vote of the board. Before the request is made to legal counsel, but then it says the person making the request to legal counsel or chair.
So it's,
So even if there's a vote, so I'm just saying, we may want to consider, like, you're saying, the board chair or designee. So it doesn't have to be the board chair that's going in, that's seeking that legal advice, because that's what you were asking. To just be put under option B, but here, this is what it would actually show up in the policy.
so
I
we,
read that to mean the board chair to do it without an authority vote.
correct,
it's just saying that the board chair's authorized to make legal advice
Okay.
or opinions.
That's,
It's advantageous to do so prior to the next meeting. So you have to get, like, the chair is authorized to get legal counsel if there's not a meeting between now and when they need the information. Otherwise, you still are supposed to get legal advice, and it's supposed to be approved by majority vote of the board.
without any, okay, I see that past the parentheses.
Correct.
Okay. I get it.
I think it still doesn't answer some of the questions that you have about, and then indemnity, but I think from a policy purpose though, it clearly takes it back to, a cost to the district. The interesting thing about it is, because we ran into it, is Pace clearly does not want, neither does the Hunger First, to take phone calls from individual board members. However, I don't think that means that they won't do it. But if I know this personally, if I were to go and say, I have an individual board member who has these questions, or they generally are thinking about this in terms of, the general answer.
You're generally wrong.
No,
It's 7:04. How do we want to?
So if you read the adjournment.
Yeah. So I think that let's finish this one. Question for this one is then, you want to leave it under the review piece? I can get some more background information as far as indemnity, how it relates to actually this policy. Or I think from what I've heard in the room is that option 2 seems to be, towards, it's left up to the board chair. Yeah, you can go ahead and adjourn and, start the regular meeting.